You know, most of us have multiple notebooks and notes and books and things like that in front of us. Can you hold up what you've been referring to in answering our questions? Is there anything on it?
That letterhead that says United States Senate.
That's impressive. Well, Judge, the best I can understand, the objections to your nomination are not to your qualifications, your experience, or training, but it's that you have or you will violate your oath of office. I find that terribly insulting. They suggest that you can't be unbiased in deciding a case you haven't even participated in yet. I find that insulting as well. You know, maybe almost as pernicious as attacking somebody for their faith and suggesting that that disqualifies them from holding a public office is the attack that's being made on judicial independence, something that Chief Justice Rehnquist, among others, observed are the crown jewels of the American Constitution and the American system. But I want to just take a little walk down memory lane here. You know, there are a lot of people who guessed how judges would actually rule on cases, and almost always they've been spectacularly wrong. I was struck by just a couple. Harry Truman said, whenever you put a man, and that he's talking about a man, but a man or woman on the Supreme Court, he ceases to be your friend. He said some more colorful things, too. But Theodore Roosevelt said about Oliver Wendell Holmes Jr., he said, I could carve out of a banana a judge with more backbone than that. And as I think about people like Harry Blackmun, nominated by Richard Nixon, who wrote Roe versus Wade, as I think about Warren Burger, you know, they were called the Minnesota Twins, and obviously over time they became sort of polar opposites on the court. I think about the attacks on Neil Gorsuch for his unwillingness to make a prior commitment on LGBT issues. He wrote the Bostock case extending Title VII of the Civil Rights Act to gay or transgender individuals. Obviously, those predictions were wrong. And then, since we're talking about the ACA, it's the ACA versus ACB, I guess. Chief Justice Roberts was the one who wrote the opinion upholding the Affordable Care Act, as you know. So I would just say that all of these predictions about how judges under our independent judiciary will make decisions are just pure speculation. But I think they're worse than speculation. I think they're propaganda in order to try to make a political point. So, Judge, you're not willing to make a deal.
No, Senator Cornyn, I'm not willing to make a deal, not with the committee, not with the president, not with anyone. I'm independent.
I just would like to hear maybe some of your thoughts on, in the Obergefell case, which established, as you said, a constitutional right to same-sex marriage, part of that decision struck down the Defense of Marriage Act, correct?
Yes, I believe so.
That was a bill that Joe Biden voted for?
I don't know about that.
I do.
Okay.
Joe Biden voted for it, Pat Leahy, and Bill Clinton signed it into law. Can you just, I'm not asking you to get into the details, but just sort of differentiate for everybody listening what the approach of a legislator is in voting for a piece of legislation as opposed to the role of a judge in interpreting the constitutionality of a piece of legislation? Are they the same or are they different?
They're quite different. a judge isn't expressing a policy view. You know, I tell my students in constitutional law that newspapers do courts a disservice when, you know, they say things like, you know, court favors same-sex marriage, or, you know, just giving the headline without showing any of the reasoning that goes into it. Because courts are not just expressing a policy preference. They're digging in, they're looking at the precedent, they're looking at the Constitution, and even when the result cuts against policy preferences, judges are obliged to follow them. I suspect that this body doesn't cast votes that conflict with their policy preferences.